Students, up till now we have discussed the basics of contract, offer acceptance and consideration. Now let us continue with the other essential elements of a valid contract. One very important video because most of the questions will be asked from this unit. So please pay attention. The first element that we are going to discuss over here is capacity to contract, who are capable of contracting. So only a major person? Yes, I think you know the answer. So say it along with me. Only a major person. Then what will you write? Person of sound mind and person who is not disqualified. Only they can enter into a valid contract. So law requires that the person must be competent, he must be capable of entering into a valid contract. Let us discuss something about minor. See, if I say that major, sound mind, person who's not disqualified, only they can enter into contract. Can I say that minor, unsound person, person who's not disqualified, person who is disqualified cannot enter into contract? First, let us discuss something about minor. Can minor enter into a contract? No, absolutely not. Any agreement with minor is void ab initio. It means it is void right from the beginning. Minor cannot give promise. He is incapable of giving promise. So can I say that minor cannot be a promiser? How will he fulfill the promise? And one very interesting case law was discussed over here, Morib versus Dharmadas Khosh. Now, what were the facts of this case? Dharmadas was a minor. He was a 17-year-old boy. He falsely represented his age and obtained a loan from a moneylender known as Brahmdat. He gave his property house as mortgage. Later he went to the court, proved that he was a minor when he executed the mortgage. Mortgage was cancelled. Brahmdat wanted his money back, but he could not recover it because Dharmadas was a minor. Now you must be wondering, ma'am, where is Morib? Well, she was the wife of Brahmdat. He died and she fought the case. So law said that nothing could be recovered from the minor because you cannot enter into contract with minor. Even if he falsely represents his age, the case will go in favor of the minor. Parents or guardian can, however, enter into contract on behalf of minor. So contracts which are for the benefit of the minor, they can be entered into by the guardians. Like say for example that the child wants to act in a movie. So the guardian will enter into contract on behalf of the minor. Minor cannot hold his parents or guardians liable by his acts. That's so interesting. Now let's say that a minor committed fraud. You can't hold the parents liable. Parents have never asked him to commit. That was the minor's doing. Minor took the car, went on a drive. Parents are not aware, they were sleeping. So you can't hold the parents liable for that. Minor is liable. Parents will be held liable only when minor is proved to be acting as agent of parent. Okay, so minor will be liable. Parent will be liable. I'll write it over here. The parents are liable only when it is proved that minor was acting as agent of parent. Then yes, parents will be liable because minor was their agent. Parents cannot bind a minor into contract of purchasing immovable property. It means you cannot purchase immovable property in the name of minor. It's so logical. Otherwise, people will buy a house in the name of minor and then they will not pay and tell the seller, recover it from minor. He's not giving it to us. What can I do? You file a case against the minor when you know that nothing can be done against the minor. So law has expressly said you can buy shares in his name, you can buy investments, but you cannot buy immovable property in the name of a minor. Even if minor falsely represents his age, the contract is still void ab initio, because he can always plead his minority. He can say, I am a minor. Case will go in his favor. Students, this is very, very, very important for exam. Most of the practical questions are asked on this part only. Minor cannot ratify. What is the meaning of ratification? Ratification means to go back and confirm. To go back and confirm. He cannot confirm the agreements after attaining majority. This is one common doubt which many students have. Okay, he had entered into contract during minority, and you are saying that this is void ab initio. Now, if he turns major, okay, on attaining majority, can he ratify? Can he confirm those contracts? Can he be bound? Law says no. You cannot convert this void contract into valid contract. So this will continue to remain void. Again, very important for practical questions. See, I agree that we cannot enter into contract with minor. Nothing can be recovered from the minor. What if we have supplied the minor with necessaries of life like food, clothing, shelter, education, health, legal advice? Then law says, okay, we will allow you to recover something, but from the property. Student, section number over here is very important. This is a very important section number. So yes, you can recover, but only from his property. Minor is not personally liable. So the first point which you should remember is that his property is liable. Minor is not personally liable, okay? He is not personally liable. You can't ask him to give labor. Only his property is liable. Minor can be appointed as agent. Okay, minor can be appointed as agent, because we discussed last time, no contract, no consideration is required to appoint an agent. So even a minor can be appointed as agent. But who will be responsible for acts of the minor? Principal will be liable. Principal will be liable for acts as a minor agent. Minor cannot become a member of the company by allotment. We cannot allot shares to minor. He can't apply for shares. We cannot allot. But yes, he can become a member by transfer transmission. Only if the shares are fully paid. So you can transfer, you can transmit shares in now what is the difference? We will study when we come to Companies Act. Fully paid up shares, yes, he can be the holder of fully paid up shares if they are transferred to him. But he can't apply, you can't allot shares to him. Minor can be held liable for tort. Write on the meaning of tort. Tort means wrongful act. If it is not contemplated by the contract. Now let's say that X had given a horse to minor for his own riding. Now X gave this horse, minor gave this horse to someone else. You are not supposed to give it to someone else. We had given it for your own riding. How can you give it to someone else? That's a wrongful act. Then minor can be held liable. So minor can be held liable for wrongful acts which were not contemplated by the contract. They were not as per the terms of the contract. We did not allow you to give the horse to someone else. So students, these are few points related to minor. Just check whether everything has been correctly copied by you in the workbook. Done? Okay. All right, if you are ready, let us proceed. So that was something about minor. Now let us discuss contracts by unsound person. What is the person of who is a person of unsound mind? What is the meaning of unsound? Unsound means he is insane, mad, crazy person, not of sound mind. Okay, what is the meaning of sound then? What is the meaning of sound mind? Sound means he is rational, he is sane, he is a normal person. Yes. Can a person of unsound mind enter into a contract? No, absolutely not. But there are different cases, there are different types no, of unsound people. What if he is permanently unsound, known as an idiot? He can never enter into contract because he's always of unsound mind. Any contract by him will be void ab initio. So if he's permanently unsound like an idiot, he can never enter into contract. The contract by such a person is void ab initio. What if he is like, only sometimes he is unsound? Now, in that, he's usually sound. Sometimes he becomes of unsound mind. He's usually unsound only. Sometimes he becomes of sound mind. Now, students, what if the contract is entered during lucid intervals? Lucid means time period when he was of sound mind. Then the contract is valid, no? Because he's sometimes sound, sometimes unsound. He can enter into contract when he's of sound mind. That will be valid. But what if he's lunatic? Can he enter into contract during that time? Yes. What if he's a lunatic? Okay. During his lunacy period, can he enter into contract? No. That will be void. So when he's of unsound mind, he can't enter into contract. So quite simple in over here. The position of minor and unsound is the same as far as applying of necessaries is concerned. Next, we have persons who are disqualified from contracting by law. Such persons cannot enter into contract. They are disqualified. Now, who are disqualified? Alien enemy. Now, what is the meaning of alien? Alien means foreigner. Enemy. Now, enemy means he is citizen of a country with whom we are at war. So, alien enemy means citizen of a country with whom we are at war. Can you enter into contracts during war? Now, when there is an actual war going on, how can you enter into contract and benefit the enemy? No, we cannot enter into contracts. These are void. You can also say they are void ab initio. But what about the contracts which were entered during war, before war, sorry. Before I was not aware no that there is a war. So I have entered into contract before war and then the war is declared. Don't worry, it will be just suspended. Sorry. It will be suspended during war. Okay, it will be suspended during war. After the war, it will be revived. Revived means it will again be valid. Okay, so you cannot enter into contract during war, it's void. But I have already entered into contract, then a war is declared. We'll just suspend it, we will revive it after the war is over. Next, disqualified includes foreign sovereigns, ambassadors, diplomatic staff, representative of foreign states. Now, these people have immunity. You must have heard of diplomatic immunity. They have immunity. You can't file a case against them. Okay? We cannot sue. We cannot file a case except with approval of central government. Okay, So you cannot file a case. If you can't file a case, it means they're disqualified from contracting. It'll just be an agreement that's of no use. So these people have immunity. They can enter into contract with us, they can file a case against us, but we cannot file a case against them except with the approval of central government. Who is a convict? He is another person who is disqualified. Who is a convict? Convict means a person who is in prison. Okay, he is a person who is in prison. Now, when he is in prison, can he enter into contracts? How will he perform it? No, he cannot contract. So I'll write it. He cannot contract. What if he comes out of prison or he's on parole? When he's out of prison, but you have to report to a parole officer. Bottom line is he's out of prison, right? He can enter into contract. He can enter into a contract. So when he's in prison, he can't contract. When he's out of prison, he can contract. Insolvent. Yes, tell me, who is an insolvent person? Insolvent means he is bankrupt. How will you enter into contract with such a person? He will not perform the contract. So what are the key words over here? He cannot enter into contract relating to his property. Okay? He cannot enter into contracts relating to his property because property is not with him. It's with the official assigner, the receiver who is appointed by the court. So once this person is insolvent, we will not allow him to enter into any contract relating to his property because his property will be used to pay off the debts. He cannot sue and he cannot be sued. So neither can he file a case nor can a case be filed against him. What about a company or a statutory corporation framed under special act of parliament? Now, company is bound by memorandum. They can enter into only those contracts which are allowed by the memorandum. Like say for example, I have a garment manufacturing company. So I can enter into contracts only for manufacturing of garments. Can I enter into contracts for making tires? No. What is this act? What is it known as? You're so right. This is an ultra vires transaction. It is ultra vires. Yes, so it's an ultra vires transaction. So the company is disqualified from entering into that contract. You're disqualified. Okay, what about statutory corporations? Now this will include like say ICAI, SBI, LIC. They have their own statute. Anything beyond that. So anything beyond the statute will be ultra vires. They are disqualified from entering into such contracts. So who are disqualified, students? We have alien enemy, foreign sovereigns, ambassadors, diplomatic staff, representatives of foreign state, convict, insolvent company, or a statutory corporation under special act of parliament. They cannot enter into contracts. Please ensure that your notes are complete. So let's see if you have written everything. Just a check. Okay, next. Done? All right. Fine. So students, that was about who can enter into a valid contract. Now let us continue with free consent. Now section 13 defines consent and section 14 defines free consent. What is the meaning of consent? I want the definition. Okay. So what is the meaning of consent? It's given over there. When both the parties agree upon the same thing in the same sense, they have consented. What is the Latin phrase for it? Consensus ad idem. Yes, both parties agree upon the same thing in the same sense. Do you want to buy this pencil? So you say yes, it means we are agreeing upon the same thing in the same sense. We have consented. And this consent has to be free, okay? I can't force you to enter into contract. When is consent not free? When it is caused by coercion. Section 15, undue influence. Section 16, fraud. 17, later we will study misrepresentation. 18, mistake. 20, 21 and 22. Ma'am, you forgot 19. We'll come to that, don't worry. Now, what is the meaning of coercion? See, coercion means there is physical force. Okay, so there is some kind of physical force. Why are we using that physical force? Because we want the other person to enter into contract. So, what is the definition? It is either committing or threatening to commit. I either commit that crime or I threaten. I will kill you. I will beat you. Any act which is forbidden by the Indian Penal Code, IPC. So this is a criminal act, okay? Coercion is a criminal act. You will either threaten to commit some act which is forbidden by the Indian Penal Code, or there is threatening or unlawful detaining of some property, anything which belongs to the other person. Why are we doing all this? With the intention of causing the other person to enter into an agreement. See, coercion involves criminal activity. It involves the activities which are forbidden by the Indian Penal Code. Now, what is undue influence? Undue influence means there is some kind of moral or mental pressure. It's not physical, it's mental. Between persons whose relations are such that one party is in the position to dominate the other party. So here one party is taking advantage of the other, but there's some kind of relation, like what? Solicitor client, master servant, doctor patient, spiritual advisor devotee. See, in all these cases, there is one dominating party and there is the other party who is being dominated. In these cases, there is a presumption that the relation is such that you can definitely, the relation is only such that you can definitely exercise influence. So here there is presumption. Now the here relation doesn't mean there is blood relation. It can mean anything wherein one party is in the position to dominate the other party. And he obviously takes unfair advantage of this. Okay, he can obtain unfair advantage. This is not forbidden by the Indian Penal Code. It's not forbidden because this doesn't involve any criminal activity. Some relation is required. Fiduciary relation. Fiduciary meaning is relation of trust, relation of confidence. Okay, so there has to be trust, there has to be confidence. Only then the other party will be influenced, right? What is the difference between coercion and undue influence? So in coercion, there is physical force. In undue influence, there is mental or moral pressure. Then in this case, no relation is required. Okay, so you need not have any kind of relation for coercion, but in undue influence, some relation is required. There has to be some relation. Please highlight this, students. Threat to commit suicide amounts to coercion because you're causing some physical harm. Why have I asked you to highlight this? Because I don't want you to be confused between coercion and undue influence. See, if husband is promising or wife is not promising, if they're threatening to commit suicide, you may feel, oh, husband, wife, maybe there is undue influence, but no, it's expressly given in law. Threat to commit suicide amounts to coercion. It is coercion. It's also forbidden by the Indian Penal Code. There was some punishment, but now that 1 year imprisonment was there, that is no longer applicable, but still it's covered under coercion. Be it coercion or undue influence, they are voidable at the option of the aggrieved party. Yes, at the option of the aggrieved party, they are voidable. What is fraud then, students? What is fraud? Please highlight, it is some false representation of facts made willfully. What is the meaning of willfully? Intentionally. To cheat, to deceive the other party. I am giving out false statements knowingly. My only intention is to cheat, to deceive the other party. Either obtain money from him or I want him to enter into a contract. Now see, fraud may be committed by either by the party to the contract or by his agent or with his connivance. Connivance means support, planning, scheming. So anyone can commit fraud. I can do it myself, my agent, or I may just give the idea, planning, scheming. That's also fraud. What is the main point in fraud? What is the key word? There is intentional false representation of fact. It means you are suggesting false facts knowingly. You know what you're saying is false. So that is why this act is forbidden by the Indian Penal Code. Okay, please highlight. Hence, it is forbidden by the Indian Penal Code because there is intentional false state. Intentional. See, these acts amount to fraud. Okay, what is fraud? Suggestion as to a fact which is not true by one who does not believe it to be true. It means, what is fraud? When I suggest a fact which is false and I know it is not true, means I know it is false. In simple words, I am lying. So is it knowingly? Yes. Are you knowingly giving false statement? Yes, I am knowingly giving false statements. Even active concealment is fraud. Now, students, please note, I'll write over here, okay? No, I better write it in fraud so that you don't get confused. I have already written. Mere concealment. Mere concealment is not fraud. Why? Why is mere concealment not fraud? Because of the rule of caveat emptor. So over here, caveat emptor applies. Buyer beware. No seller will point out defects in his product. You have to check the product before buying. So if he merely conceals that there is some hole in the cloth, that there is some small minor defect, you have to check the product before buying. He won't come and tell my products are defective. Don't buy. So mere concealment is not fraud, but active concealment is fraud because you're trying to actively conceal the defect in such a manner that the buyer will not come to know about it even after reasonable examination. Like this wall is it's full of leakage. I freshly paint it. Nobody will come to know. That's active concealment. It's fraud. A promise made without the intention of performing it. I'm just promising for the sake of promising. I don't have any intention of fulfilling that promise. It is fraud. You're cheating the other person by making him believe that I will do it, but I never had the intention of performing it. Any other act fitted to deceive. Now see, human mind is so fertile. You never know what kind of fraud they will come up with. So anything which has the effect of cheating, or maybe law has specifically declared something as fraudulent, like we will be studying in auction sale. Okay, if there is pretended bidding, then it is fraud. It's mentioned. So that's fine. No, if it is mentioned somewhere, then that is also included in the definition. We are just widening the scope of the definition by including these last two sentences. Students, please check whether you have written everything properly. I'll just zoom in so that you have the entire sheet in front of you. Just check whether your notes are complete or not. I have highlighted the keywords. You have to remember them for exam. Done? Very good. Next, let us discuss what is misrepresentation. See, there is false statement, but I have made it innocently, without any intention of cheating, deceiving the other party. I'm innocent. I feel what I'm saying is true. I believe it to be true. I'm not aware that what I'm saying is false. That's misrepresentation. So yes, we agree that there is false representation, but it is made innocently, unintentionally. I believe it to be true. That is why it is not forbidden. It's not forbidden by the Indian Penal Code. Because you're innocent. Now, what is the remedy? Okay. What are the effects? Or you can also say, what is the remedy available with the aggrieved party? See, they can cancel the contract because it is voidable. Okay, so you can write it is voidable. You can either cancel the contract, it is voidable. So either cancel the contract, or you insist that no, I will treat it as valid, and now you actually perform the contract for me. So you either rescind, you either cancel, or you perform. Like now you perform it in the correct way. Okay, you actually perform it in the right way. Can you claim damages? Damages. See, over here, since the misrepresentation is unintentional, no damages. So students, you can write down, in case of fraud, yes, the aggrieved party can claim damages. But in case of misrepresentation, no, party cannot claim damages. Now, what are damages? See, you promised to give me goods at 100 rupees, but in the market they're available, at only 60 rupees. You're charging 40 rupees extra from me. You have falsely made such statements. You have cheated me. You have hurt my goodwill, reputation. Now, these are the damages. You're charging extra from me. You cheated me. You hurt my goodwill, reputation. Those damages. Students, where is section 19? See, in case the contract is caused by, the consent is obtained by coercion, undue influence, fraud, misrepresentation, then the contract is voidable. But if the consent is obtained by mistake, then the contract is void. This is written in section 19. Basically, it tells us that in case of coercion, undue influence, fraud, misrepresentation, the contract is voidable. Okay, so coercion, undue influence, fraud and misrepresentation, it is voidable. This is written under section 19. Lastly, let us discuss mistake, section 20, 21 and 22. Now, mistake may be either mistake of fact or mistake of law. In mistake of fact, we have bilateral mistake, unilateral mistake. Now, what is the meaning of bilateral? Bi means two. Both the parties are mistaken as to some very important material fact. So, what are the key words? When both the parties are mistaken as to an important, essential fact, then the contract is void ab initio. Let's say, for example, X and Y, they both believe that the horse is alive. But what is the fact? The fact is that the horse is dead. Okay, so we feel that and both are mistaken. Do you really think it is of that they should enter into contract? Is it of any use? The contract is void ab initio. Both are mistaken. But what if it is mistake of just one party? Law says, see, if it is mistake of just one party, why should the other party suffer? Contract is valid. So generally, unilateral will not make the contract void. So generally it is not void. Because why should the other party suffer? There are, however, two exceptions. So what are the exceptions in this case? When we are mistaken as to identity. So there is mistake of, you can write down, identity. Or there is mistake as to nature of document. In these cases, even though it is mistake of just one party, the contract is void. These are exceptions. Generally, it is not void, means it is valid. In these two cases, it is void. Mistake of Indian law. Oh, superb. Can you say, I don't know the law of my own country. I'm so sorry. I was not even aware of it. Law says nothing doing. You are supposed to know the law of your own country. It's not voidable. Not voidable. Can I say, in other words, the contract is valid? Why is it valid? Reason is also given to you, because one is expected to know the law of his own country. You cannot say, I am not aware. But I can't be expected to know the law of each and every country. What if I am mistaken as to some foreign law? Then contract will be void if both the parties are under mistake of some foreign law. Law is silent as to what if it is mistake of just one party. Then I feel we should consider the facts and circumstances of the case to decide whether it is valid, void, or voidable. Students, please check whether your notes are complete, because with this we have quickly completed free consent also. That was so amazing. It's a time bound revision. Yes, don't you agree? It's a very time bound revision. We are not only revising, but we are also writing and practicing. Students, see, this will move like a film in front of your eyes. Mark my words, you will remember me in the exam and you will say, ma'am, everything that we had written was playing in our mind like a film. All this will come in front of your eyes while writing the exam. That's a promise. All right. Have you written this? Just check. What about this? All right, done. Let's proceed. You can always pause the video. You can always go back. That's the beauty of these revision lectures. You want to watch it again, you can watch it n number of times. If you have missed out something, you can go back and view the lectures again. Something very important for not theory, but I think for practical questions. Many questions are asked on this part. Unlawful object, unlawful consideration, section 23. Okay, so we are discussing section 23. Unlawful object. Now, what is the meaning of the word object? Object means the purpose for which the contract is entered. That purpose must be lawful. What if it is unlawful? Then the contract is void. So simple. Now, when is the object or consideration unlawful? When it is forbidden by law. Wow, as soon as I read the word forbid, the word illegal should pop up in my mind. So yes, if the agreement is forbidden by law, it is illegal, contract is void. It is defeating the provisions of some other law. So if I consider this consideration, this contract as void, it will defeat some other law. I don't want to mess with some other law. There it is written, contract is void. We also agree contract is void. Any agreement which has a fraudulent object, like say for example, X, Y, and Z, they cheat A and they obtain money from him. Okay, this is nothing but fraud. It is unlawful object, and this is unlawful consideration. So unlawful object, unlawful consideration, because whatever money you have received is as a result of fraudulent activities. If you enter into an agreement causing injury to a person or property, now over here, injury does not mean only physical injury. It also includes loss of reputation, loss of opportunity, money, etc. Consideration is immoral. It is against our upbringing, society, morals, values. Over here, generally, the example of a prostitute is asked, that you give ornaments on rent, you give house on rent to a prostitute. So we will write down example, ornaments or house given on rent to a prostitute. This is one very common example. Next, we will discuss consideration which is opposed to public policy. Trading with enemy. Can you enter into contracts during war? No, they are void. Okay, we cannot enter into contract during war. They are void. Stifling, prosecution. To stifle means to stop oneself. To prosecute means to file a case. So you're stopping yourself from filing a case. You're not reporting a crime. You're not reporting some wrongdoing. It's against the society. Marriage brokerage contract. Now over here the key word is brokerage. Is marriage some deal? Are you selling the boy? Are you buying the girl? No. It's not a deal. So if, let's say for example, A gets P and Q married for some consideration. He said, if they marry, you have to give me 5,000 rupees. This is my business. You're like a broker. You'll get money if the marriage takes place. You're like a broker. Marriage is not a deal. Now you must be wondering, ma'am, then what about Shadi.com, matrimony.com? See, they are just platforms. They are just listing places, They don't arrange the deal, that you have to do it. So they are just providing you services. They are not brokers. Any agreement which interferes with the course, with the system of justice, like bribing the judge, the police, that's against law. You're moving against the society. Contract is void. Interest against obligation. Now interest here means money. You are getting money to go against your obligation. It's void. Agreement which creates monopoly. Okay, any agreement which creates monopoly, like only you will be allowed to sell vegetables in this area and no other person. That's void, no? It means you will charge whatever price you want. Sale of public offices. Public offices, you can write down, means government jobs. So the deserving candidate will be left, and the one who's ready to pay money, he will get the job. That's not fair. Next we have Trampoli and Maintenance. These are two very similar terms, but there is some slight difference. Let's say that A promises to help B by giving him money to fight a case, okay, to file a case. He is giving money to file a case. And he tells B that if you win the case, you give me 20% of whatever you win. If there is sharing, okay, if there is sharing, then it is Trampoli. If there is no sharing, then it is maintenance. Now X has given Y some money to file case against Z. Now there is no sharing of proceeds. Y will return that money, but he will not share what he receives from Z. There is no sharing. This is maintenance. Now, ma'am, why is it against public policy? Like, if you help someone by giving him loan and all for filing a case, I don't think that should be against public policy, no? See, in India, there is some confusion. If my intention is once he gets the property, I will keep it 100%. If your intention is not good, if it is in bad faith, then the agreement is void. If it is in good faith, then it is valid. Students, please check whether you have written everything properly. Done? Okay. Now, these are agreements which law has expressly declared void. They are expressly void. Consideration is unlawful in part, section 24. It means consideration is like partly lawful, partly unlawful. Law asks me, can you separate them? Can you separate both of them? If yes, then the legal part will be enforced and the illegal will become void. So law is asking me, can you separate legal from the illegal? So it can be separated. Then the legal part will be valid and the illegal part will become void. So if a contract consists of two parts, one legal, other illegal, if you can separate, legal will be valid, illegal is void. But it's not possible. You cannot separate it. Cannot be separated. Then everything becomes void. You cannot separate, everything is void. Agreements in restraint of marriage, section 26. You can't stop someone from marrying a person of his or her choice. India is a free democratic country. You cannot stop someone. Now let's say that X gave money to Y, let's say 5 lakhs, and asked him not to marry Z. If you don't marry Z, I will give you 5 lakhs. You can't stop someone from marrying a person of his or her choice. Such restricting, stopping agreements, they are void. But there is an exception. Restricting marriage of a minor is valid. You can stop minor's marriage. Let's say, for example, X told Y, please don't get your minor daughter married. Okay, don't marry your minor daughter. I will pay you 5 lakh rupees for her maintenance, for her education. I will pay. Please don't marry her before she turns 18. Marriage of minor can be restricted. This is valid. Okay, so restricting marriage of a minor is valid. It's valid. But any other restriction, that will be void. Students, this is extremely important for practical questions. Section 27, agreements in restraint of trade. See, you can't stop someone from carrying on business, trade, profession of his or her choice. We are a free country. Now, what if X tells Y, this is my area, take money shut your shop and get out. You can't stop someone from doing business, okay? Such restricting agreements which are stopping me from doing business, they are void. But as usual, there are exceptions. Under certain circumstances, we can restrict parties. Like the first one is in case of sale of goodwill. When the goodwill is sold, seller may be restrained from carrying on similar business within specified local limits. So these are the four key words. When goodwill is sold, seller may be restricted from what? From carrying on similar business within the specified local limits. Now let's say for example that X is the seller and he sold his gold jewelry business to Y, the buyer. Now buyer can tell the seller, please don't start a similar business in this area. Otherwise, who will come to me? They will trust you only. So please leave this area and you can do business in any other area. If the restriction is reasonable, it's valid. An agreement through which an outgoing partner will not be able to carry out the business of the firm for a reasonable time, this is valid. Now let's say that A, B, C, they are three partners. C left. Now we can tell him you cannot start a similar business for 2 years. We can even specify the area in this area. So you cannot start a similar business for 2 years in this area. That's valid because we know that if he leaves the partnership, he will start a competing business and he will steal all our clients and business. So we can stop him for 2 years. That's reasonable. Service agreement, most of the time questions are asked on this. Let's say for example, a management trainee has been trained. We have also sent him on various seminars, all paid, to train him, to teach him the job. Don't you want him to work in the organization for a couple of years so that you can claim that benefit from him? So over here, if the management trainee is given so much of training, we are teaching him, so we can get a bond signed from him that he will not leave the organization for 2 years. Now this seems to be a very reasonable restriction. No, you can't leave for 2 years. That's okay. We are teaching you so much, we're spending so much on you. Such service bonds, they are valid. So in case of agreement, now over here the favorite questions of the institute is that X appointed Y a chartered accountant or an article for 3 years, and he told them that you cannot join somewhere else during those 3 years. Such restriction is valid because we are training them. Yes, so we are training them. Similar example of doctor was also asked in one of the exams, that you have been appointed an assistant doctor and you have entered into an agreement that he will not leave for, let's say, 2 years. You will train him, you will teach him, so he can't leave for 2 years. So if he leaves, then yes, we can take action. So that restriction can be cast because it's a service agreement. We are spending, teaching you so much, so we want you to give something back to the organization. Students, just check whether your workbook is complete. I'll just zoom in, just run through and ensure that you have written everything. All right. Agreement, the meaning of which is uncertain. Section 29. That's our favorite example. It's fixed. X is a dealer in different kinds of oils. He offers to sell 100 liters of oil at 100 per liter. So is it valid? Is it valid? Now, over here, the kind of oil is not specified, yes or no? Since the kind of oil is not specified, it's uncertain, not a valid contract. Section 29. Yes, absolutely right. Next we have, okay, just check. It's a simple one, right? Agreements in restraint of legal proceedings. See, now you cannot stop someone from filing a case. What is the difference between stifling prosecution and agreements in restraint of legal proceedings? See, in stifling prosecution, you are not filing a case in the first place. Here, you have entered into a contract and then you're putting certain restrictions. No, you can't file a case. No, you can't file a case there. So, here the contract is entered. So, it's an agreement. It's an agreement by which one party is restricted absolutely from enforcing his legal rights under or in respect of contract. Now, the contract allows the aggrieved party, okay, the Contract Act allows the aggrieved party to sue. Now, you are telling the aggrieved party, no, you cannot sue. You cannot file a case. That's not valid. That's not valid. Aggrieved party can, you can't restrict him from taking legal action. That's void. But there are exceptions, like you refer the case to arbitration. Now, what is arbitration? Please write down. Out of court settlement. That's okay. Even though you're telling him, don't go to the court, you're giving him arbitration option. No, you can settle it out of the court. At least he has the right to take action. No, if he's not happy with the arbitrator's order, then he can approach the Supreme Court, the High Court, Supreme Court. But at least try. So over here, X and Y, they are two traders. They agree that in case of dispute, we will refer, okay, if there is a dispute, we will refer our case to arbitrator, or we will refer it for arbitration. Now, this is not void because at least you are giving him an opportunity. They are very small time dealers, they don't have that much money to go to the court. So, arbitration is a good option, no, for them. And yes, sometimes what happens is that the parties are so reputed, like, two huge companies. So, instead of going to the court, their goodwill may be affected. So, it's better that you settle it out of the court. Contracts which specify the code, that is also not void, it's an exception. Now let's say that X and Y, they agree that X lives in Delhi and Y lives in Mumbai. So they agree that case will be filed only in the courts at Mumbai. Now see, there are two places. X is in Delhi, Y is in Mumbai. They have option of filing the case at both the places. But they agree that no, we will file case only in Mumbai, not in Delhi. That's okay, no, at least you are giving them the right to file a case. If you specify the court, that is not like stopping or restraining legal proceeding. He can file in Mumbai court. The last part, wager. Section 30, section number is important. Now, wager is nothing but betting. Okay, wager is nothing but a bet. Is it valid? No, absolutely not. It's a game of chance. It's not valid. Now, what are the keywords over here? A payment of money or money's worth upon happening or non-happening of certain happening or non-happening of uncertain events. Okay. So let's say, for example, X and Y, they are watching a cricket match. X says India will win. Y says no, India will lose. They have entered into a bet. Now India may win, India may not win. That's so uncertain, no? So whether they will win or not depends on the uncertain event. That's a bet. It's wagering. Wagering is void. Okay, wagering is void. So this is the main sentence. Wagering, they are void. but collateral to wagering are valid. How come, ma'am? Now, A and B, they have entered into a bet. A lost. He borrowed money, okay? He borrowed money from C. Now, let us assume that C is innocent. He doesn't know about the purpose of the loan. Then the contract between A and C is valid. That is what we have studied up till now. But you won't believe it. In case of, this is what we have studied, we have studied this. But in case of wager, the collateral is valid. You can write down, students, even if party is aware of the purpose of loan, but this is only in case of collateral to wager, okay? Now, what had we studied earlier, that if the main is void, the collateral may not be valid. It may be void. But in case of wager, the collateral is always valid even if the party is aware of the purpose of the loan, because they are not themselves participating in the bet, right? So collateral is valid. They are always valid. Wagering agreements, they are, please write void. They are void, but in case of Maharashtra and Gujarat, they are illegal. So you can write, they are illegal in Maharashtra and Gujarat. Hence the collateral are, what should I write? Void. So if this betting is in Maharashtra, Gujarat, main is illegal, therefore the collateral will automatically become void. So C will not be able to recover his loan. But what about agreements involving skill like KBC, minute to win it, puzzles, they are valid. Involving skill, they are valid. But involving chance like wager, they are void. Horse racing, something very interesting. Horse racing. See, horse racing is considered as a game of skill. Okay, it's considered as a game of skill. That's why it is valid. But if the amount is less than 500, okay, if the amount involved is less than 500, then it is wager. But if the amount involved in that race is more than 500, then it is not wager. Ma'am, are you writing it correctly? Less than 500 is wager, more than 500 is not wager. See, it is considered as a game of skill and it is considered to be a game of rich. If they lose a few bucks, doesn't bother them. So law says that since it's a game of skill, it's valid, but the prize money should be more than 500 rupees. Then it's not wager, otherwise it is. We want to discourage poor people from betting on horse race. Just because it is valid doesn't mean you go and bet and spend your entire salary. Is lottery wager as per the Contract Act? Yes. But ma'am, we can see many people selling lottery. See, your state government allows. So if the state government allows, then you can buy lottery and you can sell lottery. But if you win and you don't get money, don't come filing case under the Contract Act, because Contract Act says that the agreement is void. It is wager. What about speculative transactions like the share market? They are valid. Why? Because they involve skill, they involve delivery of goods. Let's say X sold shares to Y. Now shares are goods. In Sale of Goods Act, we will study that shares are goods. So over here, if you are dealing in current market price is 500, you are speculating whether it will increase or decrease. I think it will decrease. Let me sell it today. You're speculating, you require skill. And when you sell it, you have to give the delivery to the other party. So there is delivery, there is skill. They are valid. Share market transactions, they are valid, no? So students, just check whether you have written everything correctly. Okay. What about this? And the last part. That's so amazing, students. With this, I think, yes. Oh, wow. We have come to an end of the lecture. The entire third unit has been revised. Do you know something? We have revised half of Contract Act. We have made last minute revision notes. I think that's brilliant. That's an amazing way of revising law. Why didn't we ever think of revising it in this manner? Students, I'm so glad that you opted for Prayas. It's the right choice that you made for learning. And if you make a right choice today, I'm very sure you will make all right choices in the future also. With this, we complete Unit 3. Now, in the next lecture, I will discuss with you Unit 4, Performance of Contract. I'll see you in the next video.